This is Colin O'Keefe here once again with today's episode of LXBN TV. The Third Circuit Court of Appeals recently handed down a very impactful ruling as it banned the use of GPS tracking without a warrant. Joining me now to discuss this decision is attorney Callie Varner. She is with Cozen O'Connor based in Philadelphia, and she is author on the firm's blog, From the Sidebar. Callie, first, can you explain the background of the case for us and also its interplay with a recent ruling by the Supreme Court on the issue in United States v. Jones? What's the relationship there?
Sure. Well, the Katzen case began when law enforcement officials were tracing a string of burglaries in the area, and they kind of nailed it down to one suspect that they were interested in. So they found that suspect's car on the street one day, recognized that it was the suspect that they were interested in. They made a call to the U.S. Attorney's Office requesting to place what they call a slap-on GPS device, which allows the law enforcement officials to track the vehicle's whereabouts. The U.S. Attorney gave them permission to go ahead and place the device on the vehicle without a warrant, so they proceeded to do so. Several days later, the GPS readings revealed that the vehicle was parked outside of one of the pharmacies that was involved in this string of burglaries. Once the vehicle started moving, they pulled the vehicle over to find that there was the suspect in the vehicle along with his two brothers. And in addition, there was equipment and merchandise from the pharmacy that had been burglarized. So they proceeded to arrest the suspects. Later on, the suspects, now defendants, moved to suppress the evidence in their trial, and the Third Circuit ended up deciding that the evidence should be suppressed based on the warrantless search. Now, this is coming after the United States Supreme Court's decision in Jones, which held that kind of left the door open a little bit. The Jones decision said that, yes, placing a GPS device on a car is a search, but they left the door open about whether or not a warrant was required for such search. They said 1 to 2 days, you probably don't need a warrant, but anything longer than that, you probably do need a warrant. What the Katzen court, the Third Circuit, held was regardless of how long that search is, how long the GPS device is placed on the vehicle, you do need a warrant.
Absolutely. With these supposed landmark Supreme Court rulings, it always seems they leave the door cracked open just a little bit. So I have to ask, is the door still open here? Have we seen the last of warrantless GPS tracking as an issue, or do you envision, future dispute on this?
I think it's hard to say at this point. The Third Circuit's decision in Katzen was the first to decide anything on this issue after the Jones decision. And I think other circuits will, of course, be required to look to the Third Circuit's decision, but whether or not they'll decide the same based on the door that was left open in Jones will be another issue. I think we'll have to stay tuned and find out what other circuits are going to do.
Absolutely. This is a very big issue, particularly in the realm of criminal law, so it's going to be interesting to see if some circuit splits come as a result of this. Once again, that was Callie Varner of Cozen O'Connor. For more of her insight on this story, be sure to swing by FromTheSidebar.com. And as always, if you're not watching us here on LXBN, you can swing by LXBN.com for hundreds more of these LXBN TV interviews and curated commentary from our network of more than 8,000 members. Thank you for joining me today, Callie.
Thank you.